I should first point out I managed to bite my tongue quite badly last night, and I'm having great difficulty articulating anything. So, if you notice rather strange uh, pronunciation, it's because I can barely move my tongue. Anyway, one of the most distinctive. There are some people who I think probably shouldn't barely move their tongue. There are some people who, frankly, should 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 should, should learn to keep quiet. And one of them, unfortunately, in the is in the American political system. One of the distinctive features of the United States is the role of the courts in restraining government power. Since Marbury versus Madison in 1803, the judiciary has been the constitutional backstop that prevents presidents from acting as if electoral victory grants unchecked authority. Yet yesterday, it's clear that that principle is visibly eroding. The actions of the Homeland Security Secretary, Kristi Noem, are a startling example of a culture of contempt for judicial restraint gaining ground inside the executive branch. In March, a federal judge, James Boasberg, issued a directive to halt deportation flights to Venezuelan detainees, not simply to pause future removals, but to return aircraft already in the air to United States jurisdiction. That order followed the administration's controversial invocation of the Aliens Enemies Act, a relic of the early republic that was never designed for situations like this. Rather than comply, Noem instructed the deportations to continue. The detainees were delivered into the harsh confines of El Salvador's mega prison and later dispatched to Venezuela in a prisoner swap. The Department of Justice itself has now confirmed that Noem made that call, yet she insists she did not defy the court, instead accusing activist judges of radicalism. This is part of a troubling rhetorical shift that we also see in the UK. The implication is that a court order can be respected only when the executive finds the judge acceptable, and that is not how the separation of powers works. The authority of the judiciary does not depend on the popularity of its ruling. So we've gone in the United States from rhetoric against judges to actually defying what they say. In the UK, we're still at the rhetoric against judges point. We haven't quite got to the point where the political class will defy the judge's decisions. But in America, we seem to have got there. It's an important constitutional lesson. The courts do not rely on their power to enforce judgments. Alexander Hamilton once called the judiciary the least dangerous branch precisely because it has no police or army. Instead, enforcement depends on the willingness of others to uphold the rule of law. When a government official, particularly one in charge of domestic security, publicly announces that their own interpretation outweighs a judge's explicit directive, the entire system trembles. Of course, the American executive has strained judicial powers and limits before. Presidents from Abraham Lincoln to Franklin Roosevelt have aggressively pushed against the courts. But yet, in most modern cases, even where the president disagreed, compliance eventually followed. The modern danger is different. It's not a temporary emergency response. It's a political movement convinced that legal limits are irritations to be brushed aside. And the practical consequence is stark. One man, wrongly identified as a gang member, was detained in El Salvador without lawful basis until lawyers forced his return. Errors became abuses when no neutral authority could intervene. The courts exist to prevent the wrong person from being marched onto a plane or thrown behind bars simply because the administration insists. Underlying this is a deeper constitutional anxiety. If the executive can pick and choose which orders to obey, then judicial oversight ceases to operate altogether. If judicial oversight collapses, elections merely determine who wields unbounded authority. And that is not the republic the founders intended. It's a presidency creeping towards impunity. The moment must therefore be read now not only as a dispute about immigration policy or the application of a 19th century statute, it reflects a strategic political effort to delegitimize judicial constraint. It tells future officials that they may ignore courts and later characterize defiance as mere interpretation. Once such habits form, they calcify. And what we see in the United States, I'm afraid we will see very soon in the UK. The integrity of the legal system depends on shared discipline. And when leaders cross the boundary between disagreement and defiance, the consequences extend far beyond the case in view. The victims may be vulnerable migrants this month. Next month it could be American citizens, British subjects whose rights conveniently interrupt an executive ambition. As I say, what we see over there, we will see over here soon. We've already got the rhetoric. I find this very worrying. What we are witnessing is not just a breach of protocol which needs to be challenged. It's a challenge to constitutional identity. Does the United States remain a nation governed by law, or is it becoming one governed by instructions from the top, insulated from judicial correction? The answer will not be given by rhetoric. It will be given by whether the courts respond with real contempt sanctions, and it will be given by whether the public, Congress, and legal institutions insist that compliance with judicial authority is not optional. If the executive can shrug at a judge, then no one is truly safe from the shrug that follows.